It's a terrible situation, but I am trying to focus on the positive of it, that that I'm learning and growing because of it.
I appreciate that, Ms. Almendinger. This is a more serious charge. People, I'm going to tell you, I have people that have come in front of me for OWI thirds, and I tell them, I try and say, hey, do you understand how serious it is if you get an OWI fourth, because it's going from a misdemeanor to a class H felony, and then you lose your privilege to operate a motor vehicle for life. I'm going to tell you, not a lot of people heed my advice or heed my statements that I make, and it's unfortunate because it is such a drastic change in the sentence from the misdemeanor OWI third to the H felony OWI fourth and the mandatory lifetime revocation of driver's license. I'm going to be honest, Ms. Almendinger, I like you. I like you. I liked hearing your testimony for the collateral attack hearing that we've had. I believe that you are an intelligent woman, that I got a good feeling from you in hearing more about you while you were on the stand, and I get a positive feeling from you while you're sitting there. You seem like a nice person. You seem like a genuine person, a person who unfortunately suffers from a substance abuse disorder, that you self-medicate with alcohol. So instead of reaching out and doing a fun activity or calling out to a friend and going horseback riding or making a craft or doing something like that, going for a walk, instead you reach for the bottle of wine or beer or whatever your choice is. It really is unfortunate because this is such a severe sentence, and it does impact not only you, your children, your significant other family and friends, because now for the rest of your life, you have to rely upon others to bring you places or to go places or to visit. It's a serious, serious implication, and it's a serious ramification for somebody's conduct. And I wish for you that you would have understood that and reflected harder upon these consequences prior to getting into the vehicle in July 20th, 2024. As a judge, it's my job to sentence an individual and sentence in accordance to at least the parameters that I am mandated to sentence. And here it's the OWI fourth. I have no choice but to revoke your driver's license for life. An OWI fifth, Ms. Almendinger, please heed my advice. I'm not going to say that you're not going to be one that is going to, you're not going to abide by the, you may not drive ever again right now. I'm not going to say you're going to drive. I'm not going to say you're not going to drive, but I'm going to tell you, please heed my advice. Heed my advice right now. And we will go on the record in the matter 24 CF 176, 24 TR 741 and 742. State of Wisconsin versus Rebecca Almendinger. The state appears through Assistant District Attorney Jose Vila in person. Ms. Almendinger appears in person with her counsel, Bruce Anderson. We're set today in this matter for a plea and sentencing. I have confirmation that Ms. Almendinger has completed our IDIP program and has sat 48 consecutive hours. Is that accurate, Mr. Anderson?
It is.
All right. So we've reached an agreement. Can you please recite the agreement for the record?
Ms. Almendinger will enter a plea of either guilty or no contest at the court's discretion to count one of the criminal complaint against her, and 24 CF 176, which will be the operating motor vehicle while intoxicated, fourth offense. The other counts will be read in and dismissed, as well as the 2 traffic citations. As she completed the IDIP program, I anticipate the court sentencing her in accordance with the guidelines. There is $1,500 of bond already posted. She has her money for Ms. Anderson for at least the first 30 days of the monitoring program. I believe that's the status.
All right. BAC .256.
It was. We are abandoning any challenges to admissibility of that evidence at this point.
All right. Did you discuss the additional community service at 225 hours?
Was that discussed with you?
And what you wanted to do with it? At the last hearing, I went over whether or not you wanted to complete that and do that as community service, or you do have the option to convert that to additional jail days at your expense. For one day, it's 8 hours of community service that would be knocked off. Therefore, it would be 29 additional days.
I guess I would like to do the community service.
All right, and that must be completed before the end of your sentence.
Okay.
Okay?
How many hours?
225.
So. How many days?
That would be 29 days. Oh, 28 if you actually work and do that. It's 28.1. However, the court rounds up.
Okay, so like basically
29 more days.
29 8-hour days of community service would
Correct.
need to be completed.
Before the end of your sentence.
Or you could take roughly 30 days of additional.
Or it would add 30 days. So essentially what that would mean is if the court grants you the ability to serve jail sentence as in house arrest with certain abilities to go elsewhere, that would add 30 days or 29 days. However, you would, what you would need to do is just that 30 days house arrest additionally, and then the additional 25 days per day for a monitor. So I don't know. So 29 times 25, that would be an additional $725.
8 hours a day. 30 days. You're more than that, don't
Yeah, I think that I should probably just do the extra 30 days because I don't, with my license being revoked and stuff, I don't know how I would be getting.
And I am totally fine with that. Just for the record, it's an additional 29 days. I know
Okay.
that give or take, it doesn't really matter to you probably, but I do have to do it precisely. And that's fine with me. Quite honestly, either way, the county is getting a benefit from that because you have additional confinement days, plus that additional money that you would be paying for the monitor does go back into the county for resources like the ability to continue to offer monitor to others. So, okay. All right. Do I have a plea questionnaire waiver of rights form?
Yes, and I'm having her sign the addendum right now. I forgot that first.
That's okay. Thank you. I do have in front of me the plea questionnaire waiver of rights form. Do you recognize this document?
Yes,
Is that the document in front of you?
yes,
And so you are pleading guilty to OWI 4th. You're 43 years old. You have 12 years of schooling. You can read, write, you understand the English language. Is that correct?
Yes.
You do suffer from bouts of depression, but do you take medications for that?
Yes.
And so did you take them as prescribed?
Yes.
And with that and or your medications, do they put you in any type of condition where you may not be able to understand or comprehend what's going on?
No.
So today you fully understand and comprehend?
Yes.
Okay. Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Okay. And so did he also go over the mandatory minimums as well as the potential maximums that you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of that plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Did you sign both of the documents, the plea questionnaire waiver of rights form, as well as the addendum?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any other election until your civil rights are restored.
Yes.
Do you understand you're pleading guilty to an OWI 4th? That means your privilege to operate a motor vehicle will be a lifetime revocation.
Yes.
Do you understand that here the state would have to prove on or around July 20th, 2024, in Burnett County, Wisconsin, you operated a motor vehicle while on a highway or roadway of this county and state, well, under the influence of an intoxicant.
Yes.
And so you understand what they would have to prove?
Yes.
You understand the minimum potential possibility could be you could be fined not less than $600 or imprisoned for not less than 60 days. But there could be a maximum possible penalty of up to $10,000 or imprisonment of up to 6 years of incarceration or both.
Yes.
You further understand that you did complete the IDIP program, which would have certain privileges, such as a lesser sentence, as well as the ability to argue to the court to have any house arrest and be on monitor.
Yes.
You understand? I'm not bound to follow any of that, even though you completed the program. You understand?
Yes.
So I could sentence you all the way up to that maximum possible penalty if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty plea?
Yes.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, there's that section called the probable cause section where it basically says what happened that day and why you were charged with crimes.
Yes.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty to an OWI 4th conviction because you are guilty of that charge?
Yes.
Mr. Anderson, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Judge, I'll stipulate to that.
Has anyone made any threats or promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he discussed with you all of the evidence and the discovery that he has received?
Yes.
Has he talked to you about a potential for any legal defenses or a lack of defenses? Like if this were to go to trial, did he say, well, we could argue this and this could come into play, or sorry, I don't find that you have any defenses?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No, ma'am.
Then as to count 1, OWI 4th in 24 CF 176 and H felony, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and merged in with count 1. The other TR matters will also be dismissed and read in. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
Thank you, Your Honor. I believe the joint recommendation for this case is appropriate. Ms. Allmendinger is here taking responsibility for her actions. She has since completed the IDAP program and has received access to resources and programming, which will hopefully ensure that she does not reappear in front of the court in this manner. I think this sentence also accomplishes the goals of specific and general deterrence, specifically deterring Ms. Allmendinger that if she continues to drive under the influence, she will continue to face harsher penalties as she has crossed over to the felony level offenses for OWIs in Wisconsin. As for general deterrence, I think this sentence accomplishes the goal by letting the public know that driving under the influence will be taken seriously and that some of these offenses can carry harsh penalties. I also believe that the need to protect the public here will be accomplished since her driving privileges will be revoked. As such, I would ask the court to adopt the joint recommendation. Thank you.
Thank you. Mr. Anderson.
I think Mr. Villa has actually correctly set forth the joint recommendation as well as the IDIP purpose as well as the guidelines. I'm thinking that Becky has now realized the seriousness of this. She now has a felony record with nothing else on her life history other than alcohol-related offenses, and it's landed here now. She's still got work ahead of her to make sure she complies with the monitor program and does whatever is required of her through that program. So with that said, I believe I have to echo the joint recommendation. I can't say enough about how Becky has, frankly, from the day I started representation of her, she has been highly communicative in response to me reaching out to her. She has been highly communicative from her end, checking to make sure if anything is scheduled or if anything else that she needs to do as we proceeded through this matter. So I think she's a responsible person, and she's 43 years old with nothing besides these drinking issues on her record. So the court to take all that into consideration in coming down with the sentencing. Thank you.
All right, thank you. Ms. Allmendinger, do you care to make any statement, tell me anything about this or about you or what you've learned? You don't have to, though.
Well, yeah, it's a pretty big wake-up call, the consequences, not only to myself, but to the people that care about me and that I care about, my children, my family, everything. And it is not taken lightly. I am sorry for my shortcomings, and I am taking seriously addressing my problems with alcohol. You know, taking a lot of different steps to find other ways to deal with the things I used to use alcohol to deal with. So it's a terrible situation, but I am trying to focus on the positive of it, that that I'm learning and growing because of it.
I appreciate that, Ms. Allmendinger. This is a more serious charge. People, I'm going to tell you, I have people that have come in front of me for OWI thirds, and I tell them, I try and say, hey, do you understand how serious it is if you get an OWI fourth, because it's going from a misdemeanor to a class H felony, and then you lose your privilege to operate a motor vehicle for life. I'm going to tell you, not a lot of people heed my advice or heed my statements that I make, and it's unfortunate because it is such a drastic change in the sentence from the misdemeanor OWI third to the H felony OWI fourth and the mandatory lifetime revocation of driver's license. I'm going to be honest, Ms. Almendinger, I like you. I like you. I liked hearing your testimony for the collateral attack hearing that we've had. I believe that you are an intelligent woman, that you, I got a good feeling from you in hearing more about you while you were on the stand. And I get a positive feeling from you while you're sitting there. You seem like a nice person. You seem like a genuine person. A person who unfortunately suffers from a substance abuse disorder that you self-medicate with alcohol. So instead of reaching out and doing a fun activity or calling out to a friend and going horseback riding or making a craft or doing something like that, going for a walk, instead you reach for the bottle of wine or beer or whatever your choice is. It really is unfortunate because this is such a severe sentence and it does impact not only you, your children, your significant other family and friends, because now for the rest of your life, you have to rely upon others to bring you places or to go places or to visit. It's a serious, serious implication and it's a serious ramification for somebody's conduct. And I wish for you that you would have understood that and reflected harder upon these consequences prior to getting into the vehicle on July 20th, 2024. As a judge, it's my job to sentence an individual and sentence in accordance to at least the parameters that I am mandated to sentence. And here it's the OWI fourth. I have no choice but to revoke your driver's license for life. And OWI fifth, Ms. Almendinger, please heed my advice. I'm not going to say that you're not going to be one that is going to, you're not going to abide by the, you may not drive ever again right now. I'm not going to say you're going to drive. I'm not going to say you're not going to drive, but I'm going to tell you, please heed my advice. Heed my advice right now. An OWI 5 mandatory prison. It's mandatory prison, a year and a half in prison, not jail, not the ability to have a monitor and be under house arrest, prison. Please think extremely careful. Think twice, think 3 times, think 4 times before you get behind a wheel if you've been drinking. And I know you're not going to drink because, or you're not going to drive because I'm revoking your driver's license. But I'm going to tell you, I see multiple people who do it anyway, and it's an operating after revocation. Please don't do that. Please don't drive. But please think harder before you get behind any wheel if you've had any intoxicants, okay? Because that's going to be a harder time for you and your family. So you've completed the IDIP program, you've done what you needed to do, and hopefully you've learned a lot of things. Hopefully you've learned that you can't use alcohol as a crutch. It will only destroy you. Hopefully you've learned that you are a good person, you deserve to have a good life, and that if you are suffering, that there are other alternatives and you can reach out or other things that you can do. This is serious. The legislature tells me it's serious. Everybody knows it's serious. Thank God you weren't injured. Thank God someone else wasn't injured or killed. I have to protect the public. And here, Mr. Vila said it clearly the public is protected because you will no longer be able to use a driver's license, drive again, or do anything like that. So with that, the court is going to follow the recommendations as it relates to the IDIP program. I'm going to admit that when I gave you the information about the community service and the fines and whatnot, I looked a step higher in the 0.2 to 0.249 range. So I'm going to abide by that because that's what I told you. I'm not going to do the harsher one of 0.25 or above. So I'm going to sentence you and fine you $2,543 in fines and fees, plus a $10 blood draw. 165 days in custody, but for the 225 hours of community service converted over, plus you had 2 additional jails, 2 days, and with 16 additional hours of community service. So I will sentence you to 192 days of jail. You won't need to get your OWI assessment or follow through. I don't know if the legislature still requires me to order that, but you are revoked for life for your driver's license.
What did you say about the assessment?
With every OWI, I'm supposed to order an OWI assessment and follow through. You should have done that with the IDIP program. So I will order the OWI assessment and follow through. Usually that's just so you can get your driver's license back, but you did the IDIP program, so that's great. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. You're going to owe a little over $1,000 more in fines and fees. I know it's going to be hard because you're not going to be able to drive to get to work, but with that, I'm going to order at minimum $75 a month to be paid. I'll give you a little bit of time to be able to cover the electronic monitor because I'm going to guess that Mr. Anderson is going to argue for that. So I will say June will be your first payment for fines and fees. So you pay the clerk up here. If you can pay it off sooner, do so, because if you miss a payment or you don't pay this back, not only will I enter a civil judgment against you because you're always going to owe it, I will issue a warrant and you could sit up to 6 months in jail. Okay? Because that's a part of the sentence as well. And with me giving you the incorrect information in the beginning, you're already getting a significant benefit.
Okay.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need your DNA. So what you're going to do is when you're done here, you're going to exit the building, go all the way around to the back of the building to day reporting for the jail. You're going to provide your DNA. In a case like this, with this felony, I'm not sure, but you may be able to have it expunged through the system, through a written letter to the Department of Justice, not to this court, to the Department of Justice. Even if you gave your DNA before, I still have to order it. I think that's everything, Mr. Vila.
I believe so, Your Honor.
Mr. Anderson?
Judge, actually, she's entitled to 3 days credit. She did the parts of 3 days and that exceeded the 48 hours by
Yes.
about 7.
Plus 3 days of jail credit. All right. I'm going to, well, you're asking for the monitor, correct?
Yes.
And she doesn't have any convictions that would be questionable or cause like dishonesty, et cetera.
No.
All right. Are you opposed?
No objection, Your Honor.
So I will grant you the ability to serve your jail time by monitor. You must be hooked up today. And you have to pay at least 30 days in advance. All right. You'll go probably meet Dave Hatch and he'll get that all set up. I am going to tell you that if there is any violation on the monitor, you will be told that you're immediately revoked and you must go report to the jail to serve the rest of your sentence. No good time, no Huber if you're revoked. Okay. When you're on the monitor, it's house arrest. You may go to work. You may go to do community service if you have other things that you want to do or just engage like that. You may go to the doctor, you may go to church, you may go to the grocery store one time a week, but you may not go to anything else unless I specifically approve it. If there's a funeral, someone close in the family dies, you cannot go unless I approve it. Do you understand?
Yes.
With the new monitors, I'm not exactly sure how sensitive they are. They are 24-hour, 7-day a week GPS monitor and alcohol monitor. All right. So I don't know if these are as sensitive as our last monitors, but I'm going to tell you, if you don't be around anything like gasoline near it or rubbing alcohol or something like that, because if that goes off and it sets that there is alcohol, I accidentally dropped a bottle of alcohol on the thing and it set it off. I wasn't drinking. I don't take excuses. You will be told to immediately report to jail and serve the rest of your time. Again, no good time or Hubert. Do you understand?
I do construction. Like when you say gasoline, you mean just not get it on it?
I'm going to guess it has to be poured on it.
Okay.
I'm not exactly sure how sensitive these ones are versus our old ones. So that might be a question for Mr. Hatch or Tessa Anderson. Okay. All right. Anything further? So what you must do right now is you must go immediately report, go to the jail, give your DNA, and Mr. Hatch will be there to hook you up. You cannot leave until you're hooked up. Okay.
Okay.
All right. Thank you. We are excellent. You are muted. I don't know if I'm going to need to hear you, but can you hear me? Okay. We will go on the record in the matter 26 CF12, State of Wisconsin versus Richard Chanel Jr. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Chanel by video conferencing in custody in Burnett County Jail. We have newly retained counsel Emma Campion appearing by video conferencing with approval of the court. We're set here today in this matter for a hearing. We can move forward and do the initial appearance today if you wish, Ms. Campion, or we can leave it on for the 11th. I will leave that to you. If you need time to speak with Mr. Chanel, I can send you into a confidential breakout session.
I don't have a copy of the complaint and I'm not sure he has one in front of him, so I don't think we could proceed with an initial today.
Okay, and that's totally fine. All right, so we're here for a bond modification request. I have received the request from Mr. Chanel himself. I haven't received a formal motion from you, Ms. Campion, but you are very newly appointed and put into the case. Are you aware that it's 26 CF12?
Just now, yes.
Okay, there you go. All right, so Ms. Campion, argument.
Yes, Your Honor. My understanding is that the bond right now is set for $15,000 cash. Mr. Chanel was arrested last week, Wednesday. I believe this is his first appearance in front of Your Honor. In the last week, he's retained counsel at no small cost to himself and his family. He's got incredible ties to the community. My understanding is that he's had his job for the last 17 years. He has longstanding ties to Burnett County. His family lives here. He owns a home here. He has no interest in leaving the area, to my knowledge. He does not have any prior criminal history. So there's, I think, no evidence that he wouldn't appear in court. Certainly the investment in counsel suggests that he would appear in court. The crimes alleged, I don't believe are violent in nature that would require an additional cash bond or consideration there. I think that a signature bond is appropriate in this matter with any additional conditions of pretrial release. I'd like to see what the state has to say before I make argument about what I think those would be or whether or not I think they're necessary.
Mr. Schmidt.
I think the cash bond should remain high. It's not primarily based upon history of past appearance. He only has one prior conviction. It's an OWI in 2013 in Minnesota. He made all of his court appearances on that. So he has a very minor record, and it's a record of appearing in court. The main concern we have is with the strength of the evidence and what the counts are. He would have cause and concern to not appear in the future. A large amount of cocaine and methamphetamine and him telling the officer that he was selling the cocaine. That's why we think the cash bond should remain high. Thank you.
All right, Ms. Campion?
I don't believe that the amount of product alleged, which may or may not include the containers that it was found in, is indicative that Mr. Chenal would not return to court. Again, he's hired counsel. He has never had a history of not appearing in court, and we need to follow the statute. And the statute doesn't say the amount of drugs you have necessarily means cash is required. Absent any other facts provided by the state, I don't see evidence of flight. And I think he should be given the opportunity to appear in court, especially given the fact that he's been sitting in jail for over a week now. And then in the event that he is able to post cash, which I expect he would be able to, I think a signature bond is still appropriate. The state has not addressed any additional requirements of bond. I would still like to hear those so I can respond to them.
Well, I hear that when people ask for requirements of bond and conditions, but quite honestly, Ms. Campion, I only do my own.
Okay.
So with regards to this matter, I have heard the arguments. Strong argument, Ms. Campion. I do agree with that. When I look at this case and I read the probable cause, the police report that was attached or included in the probable cause, there were some incriminating statements made. Now, whether or not motions are tied to that, and that's for you to determine, Ms. Campion, and for it to come before the court at a later date or time. But I have to also look at the weight of the evidence, at least the evidence that I have in front of me. And when we're looking at this matter, I do take into account, and I will take into account, Ms. Campion, the arguments that you made that he's a lifetime resident, he owns his own home, he's worked at his job for 17 years, and it is your belief, and coming through you, from him to you through me, or through you to me, that he doesn't have any desire or he shouldn't be a flight risk. However, the court does have to, again, look at the weight of the evidence that is before this court, at least at this time. And we are dealing with a Class C felony, which could mean a maximum possible penalty of 40 years of incarceration, and a Class D felony, which could mean a maximum possible penalty of 25 years of incarceration. So they are serious, and I do have to look at that aspect as well. He doesn't have a criminal history. That OWI from 2013, that's long ago. That wouldn't even come into play if we were going to a jury trial. With regards to this, the court will amend and modify bond from $15,000. There still needs to be significant cash because, again, they are very serious crimes, and the court does have to assure his appearance for coming to court and knowing what has been stated. Again, not knowing if there are any motions that will be filed or anything for the court to look at later. It is serious and it could pose a flight risk. So the court will amend down to $5,000 cash from $15,000 cash. With regards to the conditions of bond, I do have he shall not use or possess any alcohol, no illegal drugs, paraphernalia, or controlled substances without a valid prescription. He shall maintain absolute sobriety. He is subject to random testing of blood, breath, or urine by law enforcement or corrections officer upon arrest or reasonable suspicion, or on the court's directive if he's in court and the court notices or believes he's under the influence. He shall have no contact with Michael or quote, Mike Hess. He is restricted from any establishments with the primary purpose of the sale or the service of alcohol, bars, taverns, beer tents, casinos, and liquor stores. The court is also going to state that he may not leave the state of Wisconsin or Minnesota without first notifying the court and having court approval. I am open to hear if there are any other conditions requested by the state, and or if Ms. Campion, you have any condition that you would like to be heard on.
I would ask for no contact with any known gang or cartel members.
And no contact with any known gang or cartel members, and no contact with anyone who is currently on, and it's able to be determined, currently on either extended supervision or probation for the sale or intent to deliver any illegal substances.
You said no contact with anybody on ES or probation with basically a drug conviction?
Not a drug conviction, with the intent to deliver.
Okay. I have no objection at this time. I think if there's a concern, I will bring it back to the court.
All right, thank you, Ms. Campion. Thank you, then, go ahead.
I just wanted to note, Mr. Chanel, you can post it anytime.
And Ms. Campion, I'm not sure if you were able to look at the criminal complaint, but if you need or want a brief breakout session, I am prepared. We are done with the hearing. I can send you in to talk to him if you want.
Mr. Chanel, is that something you'd like?
That's up to you.
Yes, that would be great, Your Honor. Thank you.
All right, we are adjourned.
Are we remaining adjourned while they're doing that?
Yes. Oh, no,
So I
I
don't
have
need to
another
come back?
person. Well, no, yes, we have to wait for Ms. Mersha, or Mr. Mersha.
My intention was just to disconnect. Is that okay? After I?
Yep, that's totally fine. That we're all done with you in this hearing.
Okay, thank you.
I just have to find Burnett County. I have 2 jails coming in right now and they're labeled differently, so I have to see what they are. Okay, there you go. Should be good to go.
Thanks.
We have a great officer right back there. I'm good. All right, Mr. White, can you hear me?
Yes, I can, Your Honor.
We will go on the record in the matter 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Stewart appearing in person with his counsel, Nicholas White, appearing by video conferencing. We're set here today in this matter for a status conference. The court set this status because I do need to state on the record that it took some time to be able to locate an attorney who would be able to accept the appointment of this case. Mr. White has indicated that he is willing and able to do so. Because this is a serious matter, it needed the court to look at attorneys that would be experienced enough to handle a case with the serious allocations attached to it. So we have Mr. White. We currently have a sentencing in this matter scheduled for February 10th. But again, the court is stating that through no fault of Mr. Stewart's, it took a little time before the court could find an attorney that would be able to accept the appointment. We have done that now. It's just a recent appointment. And so based on that, the court cannot proceed with the sentencing on February 10th because that would not give Mr. White enough time to thoroughly look over this case and all of the discovery and all of the evidence and where it was to where we are here today waiting for sentencing. So the court will remove the February 10th date and we can set it for another date and time right now. We are in victims' rights compliance. We have victims appearing here today. Ms. Bauer, I'm not sure if they were aware of the situation that might occur, which has occurred here today.
Your Honor, I informed them.
Okay. And is there anything that they would like you to state on the record as it relates to this?
Not to my knowledge, but they would like it as soon as possible.
Yes, as soon as possible. So Mr. White, when do you feel that you could be up to speed and have looked over all of the information, the discovery, the evidence, and had meaningful meetings with your client, Mr. Stewart? How long do you think you will need?
Your Honor, I'd have to ask for a status hearing, I think would be most appropriate before doing a sentencing hearing. I would only need a couple weeks to go over everything. The question is whether we're going to pursue any type of pre-plea or pre-sentence motion or if we really are preparing for sentencing, considering the PSI and perhaps an alternate PSI. So there's just some things that I need to know an answer on before I can tell you if we're going to sentencing or when we're going to sentencing.
And I understand it. I understand you have a full practice, Mr. White, so I want to make sure that you have enough time to be able to look over all of that. So do you think that you can have an idea and we can have a status on February 27th, or is that too soon?
I think that's a little soon for me.
I appreciate your candor. Please be open and honest. I don't want to put anyone in a situation and be rushed and then have a status for nothing.
Okay.
What about March 9th at 1:45?
That gives me about 5 weeks. I think that's enough time, or 4.5 weeks, and I am available at that time.
All right, because for the record, we had to go out this far due to the court's calendar with trials, et cetera, and so that we can stay on Mr. Schmidt, the district attorney's week. So that's why we had to go out to March 9th. Anything from the state?
No, Your Honor.
Anything else from you, Mr. White?
No, not at this time.
All right, then we will see you for a status on March 9th. At that date and time, we will have a direction and set this matter for further proceedings. All right, thank you. We are adjourned.
Understood.
The courtroom fell completely silent as the judge looked directly at the defendant and delivered words that would change her life forever. This wasn't just another DUI case anymore. It was now a felony. The judge made one thing painfully clear: her driver's license was gone, for life. But the warning didn't stop there. He leaned forward and said that if she ever made the same mistake again, the next sentence wouldn't be house arrest, it wouldn't be county jail, it would be mandatory state prison. Then came the line that left the entire courtroom speechless: think twice, think 3 times, before you ever get behind the wheel again. At that moment, everyone in the courtroom understood this was no ordinary sentencing, it was a final warning.